The High Court in Makhanda has set aside the decision by Energy Minister Gwede Mantashe to grant all giant Shell the permit to do seismic surveys on the Eastern Cape's Wild Coast. It's in relation to Part B of the case in which the applicants argued that Shell doesn't have the necessary authorization to undertake the testing. The Legal Resource Centre further argued that seismic surveys would violate constitutional rights. Judgment was handed down this morning following a two-day hearing. Joining us now to explain the court's decision is Johan Lorenzen, an associate with Richard Spoor Attorneys. Johan, good to have you with us tonight here on In Focus. So, from what I'm understanding, all the parties here who are bringing this case, the lobby groups, the community, and so on and so forth, we're asking the court to, one, set aside an exploration right granted to Impact Africa in 2014, which was later then transferred to Shell. Two, to set aside subsequent renewals of the rights in 2017 and 2021. And then three, they also sought a declarator that an approved environment management program is not equivalent to a NEMA, N-E-M-A, which is something which you are going to explain, a National Environment Management Act. Right, let's start with the first one. What did the court say as far as how the rights were awarded?
Yeah, so the court didn't consider whether the rights should or should not be awarded in the abstract or whether it's good or bad. What the court considered is what process was followed and who was consulted. And what the court found is that while the Impact Africa had consulted with different individuals who had been registered previously, who had been affected by previous surveys, there was no meaningful attempt to engage with Wild Coast communities who would be directly affected. And so while there were newspaper notices put up in English and Afrikaans, along the Wild Coast, where people predominantly speak isiXhosa, there was no opportunity to make meaningful comment and to be engaged and find out what will the impact be on our way of life and our livelihoods, and how will we mitigate those impacts through consultation. Yeah. And so because of that, it was found to be unlawful.
So one of the things that comes out is that the process of compiling a stakeholder database in itself was not sufficient. But even if some of it was compiled, the places in which they sought to communicate the background information, for example, the newspapers that they sought were mostly English and Afrikaans based and not in isiXhosa, or those that they did seek were not being distributed within the Wild Coast communities. What does that mean if the company would want to do or engage in this process, again, as they've already indicated that they are still committed to a just transition kind of energy exploration in South Africa?
Yeah, I think it's a notice to all investors who are looking to be working in South Africa that if you want to do business in South Africa, you should understand the South African context. And so it's not good enough to use a pre-existing database that you have not checked who is on it and how they got added. It's not enough to just advertise in the languages that are convenient or the price is affordable. You need to be ensuring that if your activities are going to have an impact on people, particularly vulnerable people, then you need to make sure that they have an opportunity to understand the project, how they might benefit, and how they might be harmed by the project, and how you tailor the project through consultation with the people who will be affected to ensure that it has sustainable benefits not only for your shareholders, but also for the people who will be affected by your project. And so I don't think it's a particularly radical judgment. It's that to do business in South Africa, you need to engage with South Africans.
Yeah. Engagement in itself is also maybe taken a little bit further here, because especially when you're talking rural communities, some investors would assume that consultation with traditional leaders would be sufficient. But it does seem from this judgment that this would have implications going forward, that you can't just go and consult with traditional leaders.
Yes, that becomes very clear from this judgment. What happened was that Impact Africa engaged with various monarchs along the Wild Coast who were represented by a certain Richard Stevenson. And what the judgment says is that it's perfectly fine to engage with traditional leaders, and it can be encouraged. But there is nowhere in our law that it's written that traditional leaders can speak on behalf of communities without ensuring that there's a proper mandate. And it, in fact, goes further to note that historically, colonial and apartheid rulers often governed through traditional leaders. And so it's important, while we respect institutions of traditional leadership, to ensure that people represented by traditional leaders also have their voice heard. And that it's no longer enough, just as it would not be enough, Thabo, if your property was going to be affected, just to go speak to your mayor. It's not enough to go speak to a king when people along the coast are going to be affected. You need to ensure that the people who are actually being affected have their opportunity to have their voices be heard.
Yeah. So one of the issues that was argued is this particular issue that we've been canvassing now of consultation. But the other one to say, even if consultation was done, they still needed to obtain an environmental authorization in the form of a National Environmental Management Act. Now, the DMRE and Shell argued together that, well, the rights were issued in 2014. And when 2014 the rights were issued, the one environment system was not in place. And so they were arguing that an environmental authorization program under the MPRDA was sufficient as a form of authorization. What did the court say about that? I know it said the being granted the ruling in the first issue in itself does not require them to then also give a declaratory order. But what does that mean?
Yeah, that's right. So essentially, this was a right granted in 2014, and it was never quite clear why there was such concern around just applying for an environmental authorization as is required under the National Environmental Management Act. Ultimately, the court decided that it didn't need to even go there, because if the right is being taken away, then there's no need to consider whether, in addition to the right, you also need an environmental authorization. So the court ended up not going there. But what is clear is on appeal, if it is taken on appeal, that issue will still remain. But if it is not appealed and Shell seeks a new right, then it will be perfectly crystal clear that you need to obtain an environmental authorization to conduct potentially environmentally hazardous activities, as should be the case.
So, I mean, I suppose on this particular matter, that will fall away, because in anyhow, under the one environmental system, they would need to get the National Environmental Management Act approval. But what does this mean for projects that were approved prior to 2014 and their subsequent renewals?
This question is left open by the judgment. So in that context, if you have a valid right and you don't have an environmental authorization, the question still remains, can you begin blasting or mining with that right without the environmental authorization? But what comes clear in terms of Shell's right is that they were granted that right unlawfully. So the right is taken away. So the issue of whether they also need environmental authorization was not decided today.
Yeah. There are other issues as well that I don't think, but maybe you'll tell me if the courts decided on, because one of the arguments that was brought by the communities was even though you could have considered the socio-economic benefits, if there are any, but the court says, of course, there was no anything that indicated how many jobs would be created, for example, what the economic benefits would be, and so on and so forth. But others were arguing that the seismic survey would have an impact on the cultural and spiritual rights of the communities as far as the sea is concerned.
Yeah, so I think both of those points are very important, particularly as we look at going forward, whether we are going to have exploration for oil and gas. And the first point is this: while the crux of the challenge is based on consultation, what the court started to get into is, even if consultation had been done properly, what other issues were outstanding. And while we rightfully try to ensure that we have a transformative approach to oil and gas exploration, make sure that there are benefits from people who are historically disadvantaged, the court got into some of the numbers and said that there's no actual evidence of concrete benefits. So while this is while Minister Mantashe and others are trying to say this is development and this is going to benefit people, the court said, show us the numbers, and they simply weren't there. And I think going forward, it's going to be very important to engage with those details. Then on the cultural and spiritual aspects, the court also did not go into much detail, but the court did find that if you are going to be doing business in South Africa, where people do believe that their ancestors play a significant role in their lives and reside in the sea, then you need to have a process that speaks to that belief and that addresses it to the extent possible. And what it found was there was no attempt to engage with those issues, meaningful or otherwise. And so we'll be seeing if there are further applications, how this plays out. But what is clear is that there needs to be serious consideration of economic impacts, not just at a macro level, but for the directly affected communities and also spiritual and cultural impacts.
Yeah. Is this ruling appealable? I mean, the department, DMRE, saying they're still studying the judgment.
It certainly is appealable. Looking through the reasons given, it doesn't seem like there would be much prospects on appeal, but it is always open to companies to appeal, and it will be interesting to see whether Shell or Minister Mantashe appeal.
Your time. Thanks so much for coming on. He's an associate with Richard Spoor Attorneys.